All right, I think we are recording. Hi, it's good to see everybody. How you guys doing? Hope you had a good weekend. Yeah. We are kind of nearing the finish line, but you know, the first year of law school is kind of a marathon. And so run past the finish line and you'll do fine. And this one's kind of a marathon with like a steeplechase thrown in right at the end or something. So you guys are doing more than the average first year class has to do to get to the end of the first year. So I wanted to kind of first talk about the exam and how I'm anticipating that going and procedures and advice for that, and then take some questions about that. And then I've received about 5 questions from people in the class about particular subject matters. And so I will go over those questions and give you answers. And then I will be happy to keep taking questions from people as long as people want to hang out and ask them. This will be your last chance to ask questions before the final exam about the substance of the property material. And so when we are done with recording this session, I'll put on an ELC, and then it will be kind of the time for the exam to start probably tomorrow sometime. In terms of exam format, I am planning one long essay question. This is about the same length as an essay question I would give you in a 3-hour exam if it were kind of an in-class exam. My plan is to put it up tomorrow in a module on our ELC page so that you will be able to download it whenever you are ready to take the exam. And there's no time limit on it. You are welcome to work on it all in one sitting or a few hours at a time on different days or whatever. But I need you to turn in your answer before the end of the exam period. So I'm saying 4 o'clock on May the 13th, Wednesday, which is the last day of the exam period. It is an open book, open note exam. You can use your personal outlines, you can use commercial outlines, you can use group outlines or other study materials. In terms of what will be most useful to you, my grading will be based principally on what we studied together. And so the book itself and class notes or things coming out of our class discussion are the things that I think will be most helpful to you in trying to answer the exam question. You may not get help from any other person in either analyzing or writing your answer for the exam. So you know, it's to be done individually. Don't communicate with anybody else about the exam until the exam period is over. Even if you've turned yours in, you don't know who else might still be working on it. So try not to talk among yourselves about the exam until after May 13th. I had some advice for you all in the last session about how I go about grading. So let me kind of talk about that so that you can think about how to use your time. There will be a word limit on the exam of 2,000 words. And so I suggest you use kind of standard word processing software, something like Word or that will have a word count function at the bottom of the screen, and you can see how you're doing on the word usage. And so when I am grading an essay exam, I do not put a cap on the total number of points possible. What I do is I prepare a grading sheet where I have analyzed the problem and have tried to identify what I think are the major issues it presents. And I've kind of pre-assigned points for things that people might say in analyzing that problem. Those points usually come from either accurate statements of legal principles that are relevant to analyzing the problem, or to what I think are plausible ways of analyzing the facts in light of the legal principles. And so as I'm going through your exam, if I see you mentioning one of the legal principles that's on my exam sheet, I might give you a point for that. If I see you talking about the facts in a way that shows how to apply it to the facts. And I think it's a plausible answer. I may give you a point for that. And so, you know, there are just kind of lots of available points on my exam sheet. But always it is the case that you guys will spot issues or think about arguments that I did not really foresee. And so I also include the ability to be flexible and give people points for things that you might say, even if I didn't anticipate it on the exam sheet. But there is no cap on the number of points that you can earn on the essay exam. And so I will, you know, kind of grade all the exams and kind of get a certain number of points for each of you, and that's what will be used in kind of assigning the grades for the course. Since you have a word limit, that puts a premium on kind of analyzing succinctly and compactly and yet thoroughly at the same time, right? So that you're trying to kind of spot all of the major issues, you're trying to analyze them as thoroughly as you can, but you're trying not to waste words or space in the process. This is actually a skill that is important in practice, because if you're a litigator, you will often be dealing with page limits or word limits on briefs. And I spent a lot of billable hours in practice trying to figure out how to say something in fewer words and still say it as effectively as I did before. So succinctness and yet thoroughness at the same time is what you're aiming for in your exam answer. So don't repeat a lot of things. If you said something once, you don't want to kind of repeat it. Don't be verbose. Don't kind of give me long explanations for something. You know, if you can say it more compactly, that's going to be to your advantage in the grading process. So I also, you had some advice that the library put up about how to manage your time, given that we are doing the exam period in kind of a different format than you had after the first semester. So let me pull that up and just kind of walk you through what I thought was good advice there. So I said, you know, ask the professor how much time they think is reasonable to spend on the exam. If they're going to give this exam in a normal semester, how much time would they allot for students to work on it? Like I said, actually, if I had given this exam in a normal semester, I'd give you 3 hours. But given that you have unlimited time to take it, you know, I think 12 hours is an extremely generous time to give yourself to work on this. I think you should be able to spot and thoroughly analyze all of the questions in, you know, in that period of time with no problem. But second point, feel free to add some more time if you want to relax the pace. And so if you wanted to spend 16 hours total on the exam, I think that would be perfectly reasonable. But if you're spending more than a full day on this exam, I think chances are you're probably wasting time that could be better spent doing other things. Number 3, when you first get the exam, spend the first hour or two of that budgeted time reading the exam and taking notes on issues you see and important facts relevant to the analysis of each. Then set the exam aside and do something else. 4, spread out the time that you have budgeted for working on the exam into manageable chunks based on what works for you. If you've got 48 hours to take the exam, but you think a reasonable budget is 10 hours, plan to spend 7 hours working on the exam the first day and 3 hours the second. Some of you work differently. Some of you might do better with several shorter blocks. Others might work more effectively in fewer longer sittings. So, but just break up your time budget depending on what you think is going to work for your skill set. 5, if you have multiple exams with overlapping exam periods, think about how to sequence the work in a way that works best for you. Some of you might do better concentrating on one exam until it's finished. Others might do better shifting back and forth between exams. 6, do something relaxing between work periods. When you come back for your next exam work period, you may find that you've been subconsciously analyzing the issues. 7, make sure that the exam is interspersed with plenty of time for sleep, healthy meals, and exercise. 8, once you've spent the time you've budgeted for the exam, plan to take another look several hours before the submission deadline. If it's due at 5 p.m., sit down at 1 p.m., reread the exam and the current draft to see if of your answer. If you think you've done a good job, go ahead and submit the answer before the deadline. but if that reading gives you ideas for additional improvements, don't feel bad about continuing to work on it before you turn it in. And then 9, feel free to ask your professors for time management advice. They may have tips that will help you manage time effectively on their particular exam. I've given you the advice that makes sense to me, but I'm happy to answer questions about that. So first of all, before we move into any substantive material, does anybody have any questions that you want to ask about the exam or the procedures? Oh, let me kind of go over how to turn it in, right? So it will be on ELC in a final exam module. You can download it from there. You can work on it on your computer at home with an word processing software. When you are ready to submit it, you'll go back to the ELC page, and there should be a way to upload your answer to the ELC page. And if you have any concerns or would like to be doubly secure, feel free to also email your answer from your UGA mail account to my administrative assistant, Amy Weaver, and her email will be in the exam instructions. But make sure that on the exam paper itself, you don't identify yourself or say anything that could help me identify you. Just use your 4-digit secret exam number so that I can grade them anonymously. Any questions about exam procedures or advice? All right, got a question down here in the chat. Is there any particular format for our essay answer that you prefer? Not really. That's kind of a strategic call for you to make. Obviously, it helps me if it is in narrative form, in the sense that you're not thinking a lot of things that don't end up on the page. So in the last session, I suggested don't do bullet points, do narrative, so that you're explaining to me why what you're thinking about particular issues, and not hoping that I can fill in the gaps for you. So that's one, narrative form. 2, think about how to sequence it logically so that I understand why you're moving through it in the way you are. Sometimes you can do it kind of issue by issue. Sometimes you can do it over time. So the sequencing logic could be based upon time of particular events. Just whatever makes sense to you after you've read the exam answer. But try not to jump around, especially since you got time to kind of work on the answer. Try to have a logical sequence so it makes sense to me why you're doing things in the order that you are. All right, let me see if there's another question here. So will a jurisdiction type be given in the prompt, or do we just talk through each of them, e.g. wait and see for rule against perpetuities? So you'll have to kind of see what the exam prompt is, but if I don't specify a jurisdiction or a jurisdiction type, then you should think about the reasonable catalog of possibilities that we studied in the book. Another question, Dean Beck, would you like a title or heading on the exam? No, don't give me a title or heading, don't waste time. Although if you want to kind of break up sections with kind of like, here's where I'm dealing with issue X, that's fine. It can help me in the reading process, but that's a judgment call for you to make about whether you want to use words that way. The question, if so, can we count just a substantive discussion? No, any words that get counted in your word processing word counter will get counted for the exam word count. And so that's just a judgment call for you to make to see if you think that's worth the time. Feel free to use abbreviations as long as I understand what the abbreviation is, or like if you want to say RAP for rule against perpetuities, that's a good way to communicate to me so that I understand what you're saying, but you're using one word instead of 3. Question, do we submit as a PDF or Word document? I think either one is fine. I think you can upload either one to ELC. My secretary will, it might be better to upload it in a word processing form, because my secretary is going to want to check the word counts on them, and so she'll probably convert them to PDF before she sends them to me. But, so that would be the preference, upload it as a word processing document. I'd hate for Amy to have to count all the words in the paper. Other questions? All right. So let me now kind of talk about, is somebody eating lunch? I'm getting kind of a crunching corn chip sound. Is that all right? You might mute if you're not muted until you're ready to ask a question or something. Okay, let me put up the questions that I received and start walking through those. All right, so here we go. So first question, for the fee tail, when it is a category 2 jurisdiction and A effectively disentails, creates a fee simple in C, can C buy B's divesting executory interest? I was thinking how odd it is that B continues their right to take C's fee simple if A dies without issue. So I just wanted to check that C buying B's future interest in this context is permissible, assuming B is willing. So this kind of goes back to the fact that the fee tail interest has been abolished in most American jurisdictions. Let me pull up the portion of the textbook that deals with this. All right. So I think we're down on page 170 or so in the Duke Community text. There we go. All right. So we talked about in jurisdictions that have abolished the fee tail, the authors say that you've got to figure out what do you do with language that common law would have created a fee tail estate. And so they give this hypothetical: suppose O conveys to my son A and the heirs of his body, and if A dies without issue, to my daughter B and her heirs. And in my review video on the fee tail, I kind of went through a problem in the jurisdictions that they are calling category 1 and category 2 jurisdictions. But the category 2 jurisdictions, they say in the states in the second category, statutes provide that a limitation to A and the heirs of his body creates a fee simple in A, but they further provide that a gift over to B, if A dies without issue, will be given effect in one circumstance. B will take the fee simple if and only if at A's death, A leaves no surviving issue, and not, as at common law, when A's whole line of issue runs out. B's future interest is known as a divesting executory interest, which will shift the fee simple to B if A leaves no issue at his death. So going back to the question that was asked, you see the questions on the screen now? Is that okay? So it was asked in a category 2 jurisdiction when A effectively disentails or creates a fee simple in C. This is actually, you need to think about it a little differently, because if we're in a category 2 jurisdiction, we are in a jurisdiction that has abolished the fee tail estate. And so the point of a category 1 or a category 2 jurisdiction is that the estate was never entailed. There was never a fee tail estate in those jurisdictions. They've simply kind of given you a rule about how to interpret language that would have created a fee tail estate at common law. And so in the problem that I have in my review lecture on category 2 jurisdiction, it talks about how A could transfer to C, and that C would take the estate subject to B's divesting executory interest, but that is not a disentailing the estate, because the estate was never entailed. A had a fee simple estate in a category 2 jurisdiction subject to an executory limitation, and that's exactly what they're transferring to C, is a fee tail subject to an executory limitation. But then the question is, you know, let's see, when in a category 2 jurisdiction, and A effectively disentails, can C buy B's divesting executory interest. And so this goes over the question of whether executory interests can be transferred. And the book does not really get into that. I have not ever seen that actually addressed in the context of a problem like this. I assume the answer is yes. So I assume that when C purchases from A the fee tail subject to the executory limitation, and B is the owner of the executory interest, that C could offer to buy the executory interest from B and end up with a fee simple absolute. But I haven't seen any case law or other discussion that shows that that's the right answer. That's just my assumption about how that would get handled. All right, the second question. I am reviewing for our exam, and I'm having trouble with the rule against perpetuities. I'm sure I'm not alone in this. Do you mind going over it in our review session tomorrow if this is not too late of notice? And so I thought it would help to work through a couple of additional rule against perpetuities problems that we did early in our discussion of the rule that cover some different applications of it. So we're down on page 218 in the Duke-Meter text, and I want to do problems 2 and 3 in the problems that they give us on that page. All right, so here we are. So problem 2. O conveys to A for life, then to A's children for their lives, then to B if B is then alive, and if B is not then alive, to B's heirs. And we're to assume that A has no children at the time of the conveyance. We have to decide whether those interests, any of them, violate the rule against perpetuities. Well, first of all, what interests do we have? First of all, we have a life estate in A. Second, we have an interest in A's children for their lives. That is a class gift. It is a remainder because it is possible for it to become possessory upon the natural termination of A's life estate. It is a contingent remainder because A has no children yet, so we cannot identify any member of the class. And so contingent remainders are an interest we have to evaluate under the rule against perpetuities. And then it says then to B, if B is then alive, that is also a contingent remainder. And it's contingent for a different reason. This time we can identify the taker. We know who B is, but there is a condition precedent that B has to be alive at the end of the preceding life estates. So that's a contingent remainder in fee simple. And then the other one, and if B is then not then alive, to B's heirs. And so there we have another contingent remainder in B's heirs. And the relationship between those two contingent remainders is that they are alternative contingent remainders, meaning that if one of them vests, it is impossible for the other one to vest. It will simply disappear instead of turning into an executory interest. And so since we have a life estate and then 3 contingent remainders after it, there is also a reversion in O. That O has a reversion because he had a vested fee simple estate. The only vested estate he's given is a life estate, and that's an estate of a lesser quantum on the hierarchy of estates. So O has a reversion, but this is what the book called a technical reversion, in the sense that it's hard to imagine the set of circumstances where O would actually be entitled to possession. A's life estate would have to end, or A and A's children's life estate would have to end. I guess, let's see, you'd have to, I'm trying to think of exactly what the scenario would be, but basically, yeah, I think it involves, ending the A's life estate while A is still alive, and there are very few circumstances where that can happen. So there is a reversion, but technically it's not likely to become possessory. We don't have to worry about the reversion and the rule against perpetuities because it is an estate in the transferor, it's our future interest in the transferor, and those are deemed to already be vested at the time that they are created. And so the ones that we have to worry about are the contingent remainder in A's children, class gift, contingent remainder in B, and the contingent remainder in B's heirs. So first of all, let's think about the contingent remainder in A's children. And when you're trying to decide whether something violates the rule against perpetuities, the rule is no interest is good unless it must vest, if at all, not later than some life in being at the creation of interest plus 21 years. And so basically we have to think about what is necessary to figure out when this interest vests. What events have to happen before this interest vests? And for the rule against perpetuities, when we're talking about a class gift, the rule is for it to satisfy the rule against perpetuities, it has to either vest or fail in all members of the class within the perpetuities period of a life in being plus 21 years, or the whole class gift is invalid. So even if we had children of A and the interest was vested subject to open, it would not be vested for purposes of the rule against perpetuities. We'd still have to show that it will necessarily vest or fail in all possible members of the class within a life in being plus 21 years. So what has to happen? Well, there's no condition things that make an interest contingent are two things. One is not being able to tell who takes it, we haven't ascertained the taker, or two, some condition precedent that has to be satisfied. So in the gift to A's children for their lives, there's no condition precedent there. The only thing is we have to identify the members of the class of A's children. And so once we have identified all of A's children, then at that point, we will know all members of the class, and it will be fully vested in all of them, or if he never has children, the interest will fail and will therefore satisfy the rule if it's within the perpetuities period. And so under the rule against perpetuities, if you're talking about an interest in A's children, the assumption is all of A's children will be determined by the time of A's death. The rule assumes you can't have children after you die, and so by the end of A's lifetime, we will know all of the people who are A's children, or we will know that A never had children. And so either way, that interest will fully vest or it will fail within a life in being. A is your validating life. We will know at A's death whether there's anybody who satisfies, who is entitled to take. The interest will not remain contingent after A's death. And that's what the rule against perpetuities forbids, is an interest that remains contingent for too long. Here, we don't even need the extra 21 years that the rule gives us. At A's death, we will be able to identify all of A's children, and so that class gift will be fully vested in all members of the class at that time. The next future interest, then to B, if B is then alive. And so here we have a gift in an individual, B. It's a contingent interest, though, because there is a condition precedent that B has to be alive in order to take. And so do we have a validating life who can show that this interest will vest or fail within a period of lives in being plus 21 years? Well, O can't necessarily be your validating life. It is possible that O could die tomorrow. A could have an afterborn child, Z. A and all of A's other children could die, and then Z could live for 30 more years and die at that point, at which point B's interest would vest. So O can't be your validating life. A can't be the validating life for the same reason. And since there are no children of A who are lives in being at the creation of interest, they don't work either. Nevertheless, this interest satisfies the rule against perpetuities because B can be his own validating life. B is a life in being at the creation of the interest, and there is a condition precedent that B has to survive for his interest to vest. So we will know by the end of B's life whether this interest is vested or not. If he has survived A and A's children, then his interest vests. If he doesn't survive A and A's children, then his interest disappears. It does not remain contingent longer than a life in being. You don't even need the extra 21 years. So B's interest satisfies the rule against perpetuities. Thing about the rule is you only need one validating life. So even if there are some people who don't work, the fact that you can find one is enough to show that the interest satisfies the rule. And then the alternative contingent remainder in B's heirs, there it is an alternative contingent remainder, so that if B does not survive, at that point, we will be able to identify B's heirs, and there's no other condition precedent other than that B not survive, and so that interest will vest upon the death of B, and so B can be the validating life for that interest as well. As I said, the reversion doesn't require validation because it's assumed to be vested when it was created. Problem 3, I also wanted to walk through. O, a teacher of property law, declares that she holds in trust $1,000 for all members of my present property class who are admitted to the bar. Is the gift good? Here we have a very literal class gift, right? It's a gift to members of the class who are admitted to the bar. Is that interest good under the rule against perpetuities? Well, it's a class gift, so we have to know whether it's going to vest or fail as to all possible members of the class within the period of the rule. And O cannot be your validating life. It's quite possible that O would pass away tomorrow, and that some member of the class would be admitted to the bar 50 years later, and so the interest would vest more than 21 years after O's death. So O is not your validating life. Nevertheless, this interest is good because it will necessarily vest or fail as to each member of the class within the lifetime of the longest living member of the class. And all of the members of the class are lives in being at the creation of the interest. They were there to hear the promise. And so by the death of the last member of the class, we will be able to identify all of the people who are entitled to the class gift, and that they were members of the class and they were admitted to the bar. And there will be nobody whose interest remains contingent after that point. And so that interest is good under the rule against perpetuities. But then the question asks, suppose that O had said for the first child of A who is admitted to the bar, this interest violates the rule against perpetuities. This one is in an individual. It's the first child of A admitted to the bar. But neither O nor A can serve as your validating life, nor can any children of A who happen to be alive when O says it. It could be that O and A, or it could be that A has another child after this gift is promised. So we'll call them Z, an afterborn child. And then it could be that O and A and all of A's children who were alive at the time that O said what O said pass away, and that Z then lives another 40 years and is admitted to the bar and has an interest that vests more than 21 years after any life in being at the creation of the interest. And so that interest does not satisfy the rule against perpetuities and is void under the common law version of the rule. Of course, remember that there are alternatives like wait and see or the uniform statutory rule against perpetuities that might allow you to kind of wait for a period of time to see whether that interest does vest within the relevant period. But okay, so those were the two problems I wanted to walk through. Let me pause now and see if there are questions. So I've got one rule against perpetuities question here. Is it safe to always assume that a named party is alive at the time of the transfer, or does that assumption have to be stated in the prompt? I am hopeful that it will be, at least in my exam, I'm hopeful that it will be obvious from the prompt. And if I don't make it obvious, I apologize for that. But you know, I think hopefully the context will tell you that, or in real life, then you'll be able to do some investigation to see if the named party was alive at the time that the interest was created or not. Let's see. Any other questions about the rule against perpetuities? Are we good on that for now? We can come back and ask more questions about it later, but let's kind of keep marching through the questions that your classmates submitted. Okay. Question 3, during tomorrow's review session, can we go over the elective share statute and marital interests? In particular, can we review a problem from class that went over the differences between community and separate property when a spouse dies? And so I wanted to kind of review one of the problems that we did in our class discussion. Andrea was unmarried. She owned Blackacre worth $100,000. She later married Bailey. After the marriage, she earned $100,000, which she deposited in a separate bank account. She inherited a painting from her grandmother worth $100,000. Andrea and Bailey bought a house worth $200,000 as joint tenants with right of survivorship. Andrea passed away, leaving a will that devised all of her property to her sister. What do Bailey and the sister get in a community property jurisdiction, or in a separate property jurisdiction, which gives a surviving spouse an elective share of 1/2 of all probate property? And so here, the first thing we've got to do is kind of classify the different interests that are the different kinds of property that are in Andrea's estate, or in which she held some ownership interest at the time of her death. And so let's talk about it first from the perspective of a community property jurisdiction. Remember, there are like 8 or 9 community property states in the United States. And these are states that say that when you have a married couple, that any earnings of either of the spouses during marriage is community property. On the other hand, property that they bring with them into the marriage, or property that they acquire by gift or inheritance or devise after the marriage, is separate property. And so let's think about the different pieces of property here. First of all, we've got Blackacre, which she owned before she was married. So in a community property state, that would be Andrea's separate property. And then after she gets married, she earns $100,000. So that is earnings during the marriage. That would be community property. She inherits a painting from her grandmother worth $100,000. So that is separate property, because even though she acquired it during marriage, she acquired it by inheritance rather than by earnings. And then we have the house, which Andrea and Bailey have purchased as joint tenants with right of survivorship. And so that is, even if it was acquired with some community property, apparently there's been some kind of a transaction in which they've agreed to convert it into joint tenancy form of ownership. And so when Andrea passes away, what happens to those various pieces of property? Well, with respect to community property in a community property jurisdiction, the answer is that Andrea is entitled to devise half of it, and the other half of it automatically is owned by Bailey. And so the only community property here was the $100,000 that Andrea earned during the marriage. And so that would go, $50,000 would pass under Andrea's will to her sister. The other $50,000 of Andrea's earnings would be owned by Bailey as community property. Then we had 2 items of separate property: Blackacre that Andrea owned before the marriage, and the painting she inherited from her grandmother during the marriage. Those are separate property even in a community property jurisdiction, and she has the right to devise those by will to whomever she wishes. So her sister gets that $200,000 from those separate property assets. And then the house is owned as joint tenants with right of survivorship, and therefore it passes by the right of survivorship to Bailey when Andrea passes away. And so the answer is basically, in a community property jurisdiction, Bailey's going to get the $200,000 house and $50,000, half of Andrea's earnings that were community property, and then Blackacre and the painting and the other $50,000 in community property will pass under Andrea's will to the sister. Now, let's assume we're in a separate property jurisdiction. We're told that here, this separate property jurisdiction has an elective share that gives the surviving spouse 1/2 of all probate property. So we're going to have to classify the items of property to decide whether they are probate or non-probate in character. And so first of all, the house is non-probate property. It's owned as joint tenancy with right of survivorship, and therefore it will not pass through probate. It has another mechanism by which ownership is determined at death, the right of survivorship. The other three assets, though, Blackacre owned before the marriage, the $100,000 earned during the marriage, and the $100,000 painting inherited during the marriage, those are all separate property of Andrea, and in a separate property jurisdiction, and they are all probate property, meaning that they will have to be disposed of through the probate process, and so they can be governed by the will, but are also subject to the elective share. So there's $200,000 that will pass to Andrea by right of survivorship, the house, and then there's $300,000 worth of separate property assets that will go through probate. Even though Andrea tried to give all of it to her sister in the will, Bailey has the right to elect against the will under the elective share statute and can claim half of that probate property. And so Bailey would get $150,000 through the elective share plus the $200,000 house. So she'd end up with a total of about $350,000 in assets, and the other $150,000 would go to the sister under the will. All right, problem 4, kind of a follow-on question. If a husband has a joint tenancy bank account with his friend and the husband dies and the other tenant has the right of survivorship and takes all the money from the joint account, how would the elective share statute kick in to give money to the widow? And the answer here is it depends on the jurisdiction and the precise terms of that jurisdiction's elective share statute. In some jurisdictions, like in problem 3, the elective share statute is only going to apply to probate property. And so since the joint tenancy bank account is non-probate property, it would not be subject to the elective share, and therefore the friend would just get to keep it, and the wife, the spouse, would have no claim on that under the elective share statute. There are other jurisdictions that are worried about people trying to circumvent the elective share through non-probate transfers. And so different jurisdictions will include different kinds of non-probate transfers in the elective share calculations. And so a good example is the Uniform Probate Code that has something called the augmented estate. So it includes the probate estate, but it includes lots of other things that would be non-probate transfers that get included in this augmented estate that they use to then calculate the elective share. And so if you're in a jurisdiction that includes joint tenancy bank accounts for purposes of calculating the elective share, then that would get counted in determining how big the elective share is. But that is separate from the question of how the elective share gets paid. Even if you decide that non-probate transfers like the joint tenancy bank account are calculated in determining the size of the elective share, that could be separate from the question of how you're going to satisfy the elective share. And so it's possible you might count some non-probate transfers in determining how big the elective share is, but you still might provide for the elective share to be paid out of the probate estate, in which case the friend would get to keep the money in the bank account, and the residuary taker of the estate might end up with less money because of the widow's elective share. There are other jurisdictions, including the Uniform Probate Code, that in certain circumstances require the takers of certain non-probate transfers to contribute to satisfaction of the elective share. And so if you're in a jurisdiction like that, then the friend who got the money from the bank account might have to chip in some to help pay the elective share to the widow. Then the fifth question I got was, can we review color of title, tacking, and the disability statute? And so, first of all, with respect to color of title, let me pull up the relevant part of the Duke-Minier text here. This is back in the materials on adverse possession, and we're back on page 123 is where we need to be. Okay. Here we go. Color of title and constructive adverse possession is discussed in the book on page 123. So, color of title, they tell us, refers to a claim founded on a written instrument, a deed, a will, or a judgment or decree that is for some reason defective or invalid. So, if you think that there is some document that gives you a claim to property, but you're wrong for some reason, the document is invalid for some reason, you nevertheless are said to be claiming adverse possession under color of title because you've got this document that you think backs up your claim. And there are different effects that color of title has in trying to establish adverse possession. There are a small number of jurisdictions that say that you have to have color of title to acquire property by adverse possession, but that's not a very large number of jurisdictions. In some states, having color of title will give you statutory advantages, like there might be a shorter statute of limitations if you've got color of title than if you don't. In some states, color of title may help you because it is a state where the mental state requirement is that you have to be claiming in good faith, and color of title might help you factually to establish a basis for a good faith claim. And then there's also this idea of constructive adverse possession, which is if you have a kind of a tract of land and the adverse possessor actually enters and possesses part of that, but not the whole thing. If they have color of title describing the entire tract of land, then they are said to be in constructive adverse possession of the portions even that they don't actually use, and so their adverse possession claim can relate to the entire tract, not just the portions that they actually use. And there were some problems in the book about testing that idea and the limits of constructive adverse possession. The second question that the question raised was, can we talk about tacking? That is down on page 131 and 132, following the Howard versus Kunto case. And so here's what they tell us on 131 and 132. As the court in Howard states, under American law, tacking between successive adverse possessors is usually permitted only when there is privity of estate with each other. Privity of estate exists where A, who possesses for a period of time less than the statutory period, voluntarily transfers the property to B, who then possesses for a period that together with that of A exceeds the statutory period. And so privity, basically, you're talking about situations where there's an estate transferred from one of the adverse possessors to the other. And if they are in privity, then you tack their time together for seeing whether you've satisfied the relative statutory period. If it's just sequential squatters, one person is there, then leaves, and somebody else moves in, you don't get to tack the time because they're not in privity of estate. Howard versus Kunto had a very flexible view of what constitutes privity of estate. The fact that they transferred, they thought they were transferring the property from one owner to the successor, or one possessor to the successor, was good enough for that court. even though the deed described property completely different from the property that they were possessing. And then the last issue that was raised was the disability statute. And so that is discussed on pages 132 and 33. And here, disabilities has to do with kind of provisions in statutes of limitations that might toll or pause the running of the statute of limitations because of certain disabilities affecting the person entitled to bring the claim. And so they give us a hypothetical statute down on the bottom of 132. An action to recover the title to or possession of real property shall be brought within 21 years after the cause thereof accrued. But if a person entitled to bring such action at the time the cause thereof accrues is within the age of minority, of unsound mind, or imprisoned, such person after the expiration of 21 years from the time the cause of action accrues may bring such action within 10 years after such disability is removed. And then we did some problems in class. I wanted to kind of briefly remind ourselves about problem 3, which is a good one to kind of think through these issues. O is 5 years old in 1984. We're told in 1994, O becomes mentally ill, and O dies intestate in 2009. O's heir H is under no disability. And they want to know, does the adverse possessor here acquire title in 2005, 2007, or some later date? And so in analyzing this problem, we focus on whether there were any disabilities that affected the person entitled to bring the cause of action at the time the cause of action accrued. So here, in 1984, when the cause of action accrues, O is 5 years old, and that is a disability under the statute because O is a minor. And so O gets the benefit of the disability provision of the statute. We're told that in 1994, O becomes mentally ill. And so does that affect the running of the statute of limitations? The answer is no, because the statute only focuses on disabilities that exist when the cause of action accrued. The only disability that existed in 1984 was minority. The mental illness occurred later, and so did not exist when the cause of action accrued. And the authors say you don't tack disabilities to one another. It's only the ones that existed when the cause of action accrued that mattered. And so when will the disability be removed? Well, this is a state, I think, where age of majority is 18, and so it will occur 13 years after 1984. So in 1997, the disability is removed. And under the statute that we read, O then has 10 years within which to bring the cause of action or somebody else on O's behalf. And so in this case, that would last from 1997 to 2007. And so the statute of limitations would run in 2007, and the adverse possessor would acquire title at that date. They also ask a follow-on question. If the answer is 2007, how are O's interests to be protected? The answer is, well, somebody can maybe bring an action for O on their behalf. Either parents or maybe a guardian ad litem could be appointed to represent O's interests, even when O is a minor. O could potentially bring the action himself when he it becomes an adult, but at that point he's mentally ill, so you still might need some kind of guardian to protect O and bring the action on their behalf. And those are all of the questions that I received from you all beforehand. Now, let me see if any of you have any follow-up questions on any of those topics, and then I'll let people raise other questions that they might have. All right, Kim Stiepel, go for it.
Hi. So relating to adverse possession and that kind of like disabilities, if you're a holder of a future interest and there's a ongoing adverse possession claim, maybe for like a life estate, is
Yeah.
that something where you would be able to immediately have a cause of action because that you have like an existing future interest?
So that is a complexity that is not dealt with in our skinny case book, but that they deal with in their big version of the case book. So don't worry about it, but just for educational purposes, the answer comes down to when the cause of action accrued, who had the right to bring that cause of action, and what interests are subsumed within theirs. And so let's assume that you have somebody who owns the land in fee simple, and then adverse possession begins while that person owns the land, and then they create like a life estate and a future interest in other people. Well, if the adverse possession succeeds and the statute runs, then the entire fee simple estate owned by O would be owned by the adverse possessor. On the other hand, if O had separated their interest in a life estate and future interest, and then adverse possession began after the life estate started, then A would be the person with the life estate would be the one with the right to recover possession of their property, and the running of the statute of limitations would bar a claim by A, but it wouldn't affect the future interest in somebody else. So when A died, the holder of the future interest then would have the right to come in and try to recover possession of the property.
Okay, thank you so much.
All right. Okay, so question, can you explain the two ways to show an ouster? Yeah, I'm trying to remember. This came up in one place that ouster matters is whether a co-tenant, like two people who are tenants in common of the same property, whether one has to pay rent to the other, or ouster can also come up in the adverse possession context. And so I'm trying to think, I mean, one way to show ouster is actual physical ouster, where one of the co-tenants like locks the doors, changes the locks, won't let the other tenant actually use the property. So that would be one example. I'm trying to remember, does anybody remind me what was the other kind of situation where an ouster might occur? I'm sure somebody remembers this, and I'm blanking on it at the moment. No help? Okay. Hold on, I've got my class notes. Let me see if I can search it real quick. Let's see.
The two times it talks about it in the book is on page 241.
Okay. Let me
in the Spiller case.
All right, just a second. All right, you say 241? Okay, so Spiller. Oh, okay. So ouster is a conclusory word dealing with two distinct fact situations. Okay. They are the beginning of the running of the statute of limitations for adverse possession and the liability of occupying co-tenant for rent to other co-tenants. Okay. So ouster is a word used to describe what the adverse possessor has done to the true owner of property. They've ousted them, and so they are, when somebody is occupying property in a way that satisfies the requirements for adverse possession, then the true owner is said to have been ousted from the property and has a cause of action to try and recover the property. So that's one way the word ouster gets used. The other is this situation where one of the co-tenants physically prevents the other one somehow from using the property. Remember, there was a minority rule that the notes talked about after the case, suggesting that in some jurisdictions, you have to pay rent to a co-tenant even without an ouster, but the majority rule was that you have to oust your co-tenant before you're liable for rent. All right, another question. Oh, page 241. Thank you. Somebody was giving me help. All right, other questions about those materials or other topics? George, go for it.
Yeah, I got a question. Let's say a husband and a wife enter a property with the goal to eventually adversely possess that property. And the owner shows up and says, hey, you know what, guys? Now, they enter under a color of title. So they think they own that property, let's say. And the owner says, hey, you guys can stay here for a while. The husband says, okay, thank you. And the wife says, no, we own this property and we are entitled to stay here. Do they satisfy the hostility requirement in this hypothetical?
So I may get you to write my exam question next year, because that's, I mean, that kind of factual complexity, I don't know that there's one answer that would necessarily apply in all jurisdictions. It is possible to have kind of a joint adverse possession. You can have multiple people who are trying to adversely possess property together. But the problem you're raising is, what if maybe they are differently situated factually, where it's easier to prove that one of them satisfies an applicable mental state requirement and the other one doesn't. And I've never seen a case law. I don't know how that would get resolved. It might end up being a jury issue where kind of both sides put in all their evidence, and the jury decides whether the hostility requirement was satisfied or not. And just the different things said by the spouses are just evidence going to that ultimate determination.
Okay. Now, what if we take away the whole spouse factor, and we just say a guy's in there by himself and the owner says, hey, you can stay here if you want to for a while, but the adverse possessor says, yeah, I will stay here because I own the property. If there is a disagreement regarding the right to stay on the property.
Yeah. And so I think, again, you're going to have an argument. And so, you're going to want to kind of articulate the positions that each party would take if you had facts like that. And so, the owner is going to claim this was possession by permission, and the person in possession is going to say, no, in fact, it was not by permission, because I was going to stay here whether he told me I could or not. And so at some level, it might get resolved as a factual dispute. In those facts, I think I would lean towards the view that that it was that the owner, once he knows that the person in possession is claiming that they have the right to be there, needs to do more than just telling them to go away, right? Or telling them that they have permission to be there. I think the general rule is that they have to effectively oust the person, which it could mean physically removing them, although that's problematic for various reasons, or it could mean bringing in action that gets them removed from the property.
All right, thank you very much.
All right, I have a question down in chat. Can you explain question 6 on page 218 again? I reviewed the video on ELC, but the reason for the differences between parts B, E, and F are still a little unclear to me. Thank you. All right, let me pull up that problem.